All right. Well, good morning. Thank everybody for joining us today for today's CLE. We really appreciate that. We're glad that you're with us and have an opportunity to participate, and we're looking forward to presenting on this topic. So Eric and I will break the topic up into basically three categories. So as you guys know, the title is Preparing for What May Come Next. We're going to talk about this basically in three areas, which are the incident response, and then expert witnesses and how you can use experts both actively as experts and then to assist with other areas of litigation or pre-litigation. And then lastly, we'll cover aging infrastructure and how to deal with those things as they come. The one thing I was asked to do before we get started, so I will do that now so I don't forget, is if you can please at some point during the presentation or after, if you don't mind, to the instant chat process in the WebEx, if you can send your full name and bar number, that'd be great. It'll come to me, and then we'll get that to our CLE folks, and they will take care of getting the presentation, getting you registered with the KBA for this presentation, so you get the hour. And with that, we'll get rolling. So I'll take the first section, and we're going to talk mostly in this first section about what happens when something unexpected occurs or something that's likely to lead to litigation in the following months and years, and what should happen, how that should be dealt with, best ways to deal with those things, and then the things to think about in terms of preservation of items that may be needed down the road. So first and foremost, it is always our advice, and we always suggest to clients that the first step and the guidance from legal to the rest of the organization should always be to notify and involve legal as quickly as possible. I think this is sort of obvious and common sense for us as lawyers, but not always so much when there's an emergency or an incident response occurring. So we found that it's valuable and helpful in times of calm to let the company, let the university, let the organization know that the first step should always be to notify legal and get them involved. Secondly, is document the incident. And again, for us as lawyers, we often think about this as being common sense, but it really isn't when you've got folks who are dealing with an emergency or something that has time-sensitive issues and they're trying to get that matter under control. Documenting the incident may not be the top priority. And so someone has to be in a position to take that role and to document the incident, preserve physical evidence with a chain of custody. Again, that's one of those things that I've found over the years in litigating complicated cases, in particular where there was an emergency response or some initial response to an incident or an occurrence. We may have well preserved some of the physical evidence, but there was no chain of custody. And so by the time you get to a lawsuit being filed or, God forbid, you're getting ready for a trial, you've got the evidence, but you have no way of showing how you have it and who's touched it, which can be a problem as things progress. And so we advise, and I think it's a great practice in a time of calm, and you'll hear me say that several times today, to prepare a chain of custody form and have that form available so that the folks on the ground in an incident response or in an emergency response are capable and can easily and quickly secure the evidence and then document it through the chain of custody. The next point that we suggest and recommend is that everything be photographed as quickly as possible. It's much easier today when everybody's got a camera on their cell phone, a high definition camera available on their cell phone. It's much simpler to document what's happening in real time. That can be critical as you move forward toward pre-litigation or litigation and then to a trial. Having those photographs of what happened on the day of the incident or the emergency, or the day after the incident or the emergency, is absolutely essential. And that can be helpful in a variety of ways. I've had some cases over the years where there was a question at some point in the litigation process about what the building looked like, what the field looked like, what the area looked like. And then as you get to 2 years out and 3 years out before a trial, that sometimes the memories fade and everybody has a slightly different memory of what it looked like at the time of the incident. So the photographs are incredibly important. The other point with photographs is that you should always have those photographs time-stamped and then preserved properly. And you might say, well, what does preserved properly mean? Well, it goes back to the chain of custody question. The best of all worlds is the photographs are taken and then stored in a central location in a central file that has one custodian. So the photographs may be taken by multiple emergency responders, but they will each send those on digitally in today's day to a central custodian who stores those and has those available and can testify to having those from the time of the incident. So timestamp, preserved, preferably centrally located. The next thing to talk about is the witnesses. So the other issue that often comes up is we forget, we don't memorialize the witness recollections as the incident is occurring, and oftentimes with an emergency response, we can end up with a day and 2 days and a week out, and there's still things ongoing, and it becomes difficult for the witnesses to remember what happened on the initial day of the incident. So getting those witness recollections memorialized as quickly as possible is best. There's obviously a number of ways you can do that. Written statement is one, audio recording is one, video recording is one. I'm not sure there's one that's really better. They all have pluses and negatives, and certainly all have pluses and negatives as you get ready for litigation and then have to litigate, and then if you get to a trial, that are good and bad. I would tell you that over 20 plus years of trying cases, I would always rather have the recording and then deal with whatever negatives come with the recording, because frankly, a written statement can be subject to nuance or subject to interpretation, but an audio recording, even better, a video recording, you don't have those issues. And so while that's discoverable and likely will be turned over in discovery, I would always default to having that available, because it just gives, it's a clear, concise summary of what that person remembers in close proximity to the time of the event. The next section that we always talk about and that always becomes an issue in litigation is a report regarding the incident and the preparation of a report and how you do that. And so oftentimes the preparation of the report, let me get this started here. The preparation of the report is something that is not done contemporaneously with the incident or the emergency response. It's something that is done later. We advise to get that done, or at least a draft done, as quickly as possible. The other thing that is important, and I think it's critical to remember, and something that's often overlooked, is you want those reports to use objective and straightforward language. And you might say, well, what do you mean by that? Well, it's not the time to be flowery. It's not the time to embellish. It's not the time to provide opinion. Those reports, and I think you have to advise the folks that are on the ground in an emergency response or dealing with an incident as it occurs, that reporting it in a very objective, straightforward way will always serve everyone better. And that will give you the best opportunity later to understand exactly what happened and be able to use those reports to your advantage as you get to litigation and then to trial if that comes. You don't want subjective commentary or opinion or anything like that. And again, I think it's easy to understand that if it's objective and it's straightforward, while a jury may at some point see that, that's okay. Because that is what happened on that particular day, and the witness's best memory, or the multiple witnesses' best memory of what occurred and how it occurred, and our documentation of it. The next point that I think becomes an issue often is the central location of the documentation and all of the relevant evidence. So one of the things we find often is that companies, universities, organizations are great at getting everything together, and sometimes not so great at keeping it all in one place. And so in that situation, you end up having to track it down. It's not easy to track it down. It's not been with one central custodian, which can be an issue for chain of custody, and can also frankly be troubling as you get to having to present that evidence in a hearing or a trial, because you can't necessarily discuss in detail how it was collected and how it got to the custodian, and then the custodian talks about how it's been protected over the years that have intervened between the incident and whatever event is occurring, a hearing or a trial. That includes, I think, the reports and work orders and invoices and emails, letters, anything like that, technical data, all those sorts of things are critical to have with one custodian located in one central location. You want to have those in one place so that you've got one person or maybe two people at most who are going to come to a hearing or to trial and talk about how everything was protected and kept in place and maintained over those intervening years. The one custodian rule is a great rule. Sometimes it's not possible to only have one. We all know people come and go. They retire, they leave for other employment, they die, and so you have to end up with a new custodian. The critical part of that is to document that, make sure that you document the transition of the custodian, and you document the transition to the new custodian, and that new custodian is familiar with whatever information might have been important with the old custodian. So that's just a critical point in how you deal with transitioning from one custodian to another. Let's talk a little bit about work product protection and privilege. This is always something that we want to have if we possibly can in regard to an incident or an emergency that may result in litigation. As you all know, documents that are prepared in anticipation of litigation are subject to the work product doctrine under 2602. That is not an ironclad block to that, but it's important to notate on anything that the document was prepared in anticipation of litigation. I think that helps, and it certainly at least gives us a defense to whatever may come. And if you guys don't mind, we've got, Eric and I have got just a little feedback. If everybody would just mute, that'd be awesome. I'm not sure why we're getting the feedback, but if everybody would mute, that'd be fantastic. All right, so let's go on to who does it apply to? So the policy of protecting counsel's work product prior to litigation applies to all of the parties' representatives, including the private investigators, but it's got to be noted. So the key there, what we found in litigation and in trial work, is that if you note that it's being prepared in anticipation of litigation or that it's being prepared for counsel, it's a much stronger argument for us to make that the documentation is subject to the work product protection or the privilege. Again, in recent years, we've seen some decline and some, propensity on the part of some of our judges to pierce that and to allow some things to be disclosed that probably wouldn't have been disclosed 10 years ago. But still, the effort is important and critical as you get into litigation and discovery and trial to protect those through noting that it is prepared in anticipation of litigation or prepared at the direction of counsel. The scope of the privilege is a tough one sometimes in terms of work product. It's a qualified privilege. The work product is primarily, when it's factual in nature, it can be discoverable. And you might say, well, what do you mean by that? Well, oftentimes when incident reports are prepared at the direction, even at the direction of counsel, those can become discoverable because they're largely fact-based recitations of what happened. And so you've really got to keep that in mind, that if it is a more fact-based document, it may well become discoverable. And oftentimes, if a requesting party, the opposing party, can show the court that there is a substantial need for the document and that there isn't anything that would otherwise provide the information that they're requesting. In other words, there's no substantial equivalent, and it would present an undue hardship if they're not given an opportunity to review those. More often than not, incident reports and related reports. That is oftentimes when those things will be produced. So it's always good to keep in mind as you're talking with your folks who handle emergency response and incident response in the follow-up days, to remind them that when they're creating an incident report, even if it says created at the direction of counsel, it may well be produced. And to keep opinion and superfluous thought out of those documents. We've seen in the course of litigation over the years good incident reports that were very factual and very detailed and talked just about what happened, and bad incident reports that provided way too much opinion about the investigator's thoughts relative to the incident and how it happened and perhaps whose fault it was and that sort of thing. So we really want to avoid that, and good direction to those folks that are on the ground is critical to get that out there and for them to understand how to deal with that. The next area I want to talk a little bit about today is how does the privilege impact the incident response? Well, there's a two-step standard that we rely on to determine if privilege applies. Whether the document was created because of the party's subjective anticipation of litigation as contrasted with an ordinary business purpose, and then whether that subjective anticipation of litigation was objectively reasonable under the Roxworthy and subsequent cases. You'll see down there in number 2 that incident reports that are required by company policy are in the ordinary course of business, are usually not work product. So let me break that down for you a little bit and talk about what I mean by an incident report. Oftentimes, the best policy and the best plan is to have an incident report that is created by those first responders and those emergency responders that are on the ground, that simply details what's happened and how it's happened. That would be the report as it's referenced in the Roxworthy case and in the subsequent Sears Roebuck cases. Those kinds of reports are going to be discoverable even if they're marked as privileged or created in attorney direction. So it's incredibly important to make sure that's clear. There can be a second incident report that is truly created in anticipation of litigation that perhaps provides feedback from those folks on the ground to the attorneys about potential litigation issues and other things that might pop up as the matter progresses. Those are not so much discoverable, but they can become discoverable. So I would say, as you think about that, if they're divided, that certainly is best. The argument to the court then is,
We've provided what is a factual incident report. All the remaining reports were prepared for counsel and shouldn't be disclosed. It's not a golden shield. It's not the rock wall that forever prevents those from being disclosed in discovery, but it at least gives a more solid argument in an evidentiary hearing or in pretrial motions or motions in limine. So the 2-report model is a good one. Sometimes that's tough depending on the organization, but it certainly is the gold standard when you're dealing with emergencies and emergency responses. Let's talk for a minute about subsequent remedial measures, because there is always pause about fixing something or going back to fix something after an event has occurred. The rule here is if it is something that is important and will prevent additional injury or additional problem, you want to do it. So KRE 407 is the rule that tells you how to address subsequent remedial measures and what's going to be admissible in court or not in court, in front of a jury or not in front of a jury. But certainly the best practice is always if there is something that needs to be done to prevent future injury or the same incident or emergency from happening again, you want to go back and do that. But we don't want to get to trial or pretrial and having had a second set of issues with the same building or the same field or the same equipment. That's the worst of all worlds, because I can promise you that's probably going to be admissible. And so subsequent remedial measures, while they are a tough one to deal with in the litigation world, having that done so that it's safe and the problem does not reoccur is critical. And so regardless of what the rule says, that's always the best practice and the best way to deal with this if trial or litigation is imminent. We've already talked about this a little bit, but the hesitation often with subsequent remedial measures is that it would be used against the organization, in subsequent litigation or a lawsuit. Excluding this evidence, defendants are encouraged to make the improvements. Certainly, there are strong arguments under 407 and the Evidence Rules Review Commission notes that subsequent remedial measures should be excluded from use at trial. They may well be discoverable, but from use at trial in front of a jury. Having said that, again, let me go back to what I said a minute ago. If the question is, do we need to do this to make the place safe, to make the equipment safe, to prevent another issue from happening, you absolutely need to take the subsequent remedial measure. The easy one that we all think about, and I always like to use it as an example because I think it's a pretty straightforward example that we can all follow, is if there's not a railing on the sidewalk or the steps and somebody falls and is injured on the sidewalk or the steps, putting up the railing to prevent another fall or injury is obviously the step that should be taken regardless of the rules subject to remedial measures. I've argued those on both sides. I've argued to admit subsequent remedial measures, and I've argued to preclude the other side from raising subsequent remedial measures with the jury. I will tell you, having tried dozens of cases that had some aspect of subsequent remedial measures involved, whether that be an explosion or some sort of catastrophic event in a building or a catastrophic healthcare event, in my opinion, the jury wants to know that the organization has taken steps to deal with whatever the issue is. Whether there is a question of liability or not, or a question of culpability or not, a jury will most often want to know that something has been done so that the incident doesn't happen again. And that's the fallback when you're getting ready for a jury trial in terms of what's going to be presented and what isn't going to be presented. All right. Couple cases that talk to us about subsequent remedial measures. Post-accident unsafe condition reports. and union grievances concerning post-injury corrections under 407 are likely subsequent remedial measures. Affirming the Davis case is a good one because it affirms the exclusion of expert testimony on alternate techniques of applying a particular process, which I think is helpful because that, again, there are a couple ways to look at subsequent remedial measures. One is the sort of basic one that I just talked about, putting up the railing or, covering the hole or something like that. And a second is, could something have occurred a long time ago in the construction process or in the maintenance process that would have prevented this from happening? And oftentimes, under the Davis case, you can prevent experts from second guessing what happened in the construction or the maintenance or the normal upkeep of the building or the equipment or the work area that's involved. And so I think that's important to know that's a good argument and one that we often win to keep out the subsequent remedial measure, expert testimony. The other purpose exception is one that really doesn't come into play too often. Often it's involving ownership, control, or feasibility of measures. I haven't seen a lot of cases where we've had that issue of ownership or control. Admittedly, a lot of the cases I've handled that would involve subsequent remedial measures are fairly large-scale explosions or again, a catastrophic event. And there's not much question about who owned the equipment or the property, or at least who owned it and leased it and that sort of thing. That relationship is usually well documented. But it's at least worth noting that subsequent remedial measures can be brought into play and can be admissible in front of a jury if there really is a strong question about ownership or control of the particular property or the equipment or the area that's at issue. Basically, this goes back to my first point, which is when should repairs or corrections be made after the incident. If it's a matter of safety, it should be made immediately. Again, my rule at the beginning is if this is something that's going to make it more safe, make it less likely for a second incident to occur, make it feasible for the public who might be utilizing the equipment or the facility or the road, sidewalk, etc., it needs to be done immediately. If it's a business decision, and we have this happen a lot in the manufacturing world, whether that be whatever area that might be in, whether it's large-scale manufacturing or more labor-intensive manufacturing, there's really not a hard deadline there as long as the safety is addressed. So the business decision, the timing for a subsequent remedial measure is not as important. And then I'll just finish that with, again, when in doubt, make the SRM because you don't want to have that thrown back at you in litigation or in a trial setting. All right. Well, that's the first part of our presentation in terms of how to respond to the incident. And I'm going to turn it over to Eric to take over to presenting on experts.
All right. Thanks, Craig. Before we move on, I just want to repeat the announcement Craig made at the beginning because I think there's some who jumped on after he made it. And that's if you would please send a message in the chat function with your name and bar number so we can make sure we get that recorded for the CLE credit. All right, so I'm going to talk about experts. As you all know, experts are critical elements in most litigation. Us lawyers like to think that the juries hang on our every word and we win or lose cases, but the truth of the matter is experts play a big part in that. And a good expert can win you a case. A bad expert, frankly, can lose you a case. So here's what I'm going to go over. So when do you want to use an expert? And what type of expert do you need? What issues do you need them to address? How many do you need? Where do I go to find an expert or experts? And once I finally found them, how do I effectively use them? So let's start. Okay, so when do you need an expert? And the short answer is, in most cases, As we all know, in cases you're going to have your fact or lay witnesses and you're going to have your expert witnesses. And the difference between the two, pretty obvious. The experts are the ones who have the scientific, technical, or other specialized knowledge. And the court is going to permit an expert's opinion under KRE 702 if the expert has scientific, technical, or specialized knowledge that's going to assist the trier of fact to understand the evidence. And he has to have the proper skill and training. And his opinions have to be based on sufficient facts and data. It has to be reliable. So that's the standard under the Kentucky Rules of Evidence as to when experts can come in. And to just summarize, basically you can use them to help you in a case on issues that wouldn't be within the common knowledge of the average person. As long as they're well qualified, they use the facts that are available in the case, and they apply the facts to principles, and they come up with their opinions in that way. Now, there are those times when either you or the other side is going to say, well, hold on, I don't think this expert meets those standards, and you can challenge that in court. I'm sure you all remember it. It's the Daubert challenge, the Daubert standard, and Kentucky has adopted that standard in the Toyota Motor Corp versus Gregory case. And in that case, Supreme Court of Kentucky held that they formally adopted the Daubert standard and reaffirmed the application of the Daubert's flexible analysis to all expert testimony, not just scientific testimony. And for those of you who have been through litigation, you know that in most cases you're going to try that Daubert motion if you're on the other side. Truth of the matter is, at least in Kentucky State Court, it's hard to win them. But just know that that standard does exist, and you want to make sure when you're selecting your expert that they're appropriately qualified, and that you give them the correct information, and they actually use the information you give them to come up with their opinions, so that it's airtight, and there's no way that you're going to get your expert excluded. Again, so experts, they can help present arguments in most cases, and they're going to be permitted in most cases. An example where you may not need them or where they may not be permitted is if it's a very simple, straightforward, obvious case where expertise is not needed from someone, meaning that the common layperson can understand, okay, something went wrong there. Just some very general, basic examples where it's easy to know, all right, you don't need an expert. Like if a surgeon amputated the wrong leg. So if there was an X on the right leg and the surgeon, amputated the left leg, that's going to be one where a jury's not going to need the opinion of an expert to come in and tell them that that was the wrong thing to do and that was negligence. Another example might be if a commercial property owner, they dug a 10 by 10 hole on their property and didn't cover it up, didn't place any warning signs, and somebody fell in it. An invitee was there and they fell in the hole and got injured. That might be another example of where you don't need them. So basically it comes down to the common knowledge thing. If there's common knowledge that something was wrong, then the court may say, well, hold on, we don't need an expert in this situation. There may be times also when you just don't want to use experts. And like I said, most of the times you are going to want to use experts, but there are times when you won't. And those cases can be particularly where there's a low value in the case. As we all know, if you've dealt with litigation, experts, they charge an hourly fee, and that can often take up a big part of your litigation budget. So there might be a case where, the value of the case is such that you don't think it warrants hiring experts or multiple experts. Instead of hiring the expert, maybe what you do instead is use someone internally who's an expert on the issue. That way you don't have to go out and spend the money and hire an expert. Okay, so we talked about the legal requirement and standard for what qualifies an expert, and now we want to talk about what type do I need, how many do I need. So when are they strategically advantageous? Sorry, how long? Oh, there we go.
Okay.
Sorry about that. So when should experts be used and in what form? There are consulting experts and there's testifying experts. And you have to think about what's going to be best for my case. And in many cases, you may want both. And a consulting expert, you might hire pre-suit, so right after an incident like Craig talked about, to help you strategize and work on the response to the incident And they may end up becoming a testifying expert for you, or you may just want to keep their groundwork that they laid and use that for your strategy going forward and not ever disclose them such that the other side doesn't learn about them and isn't able to obtain their opinions. And then you have testifying experts, and those are going to be the folks who you bring to trial, and they're your all-star. They're going to sell the case for you. They're going to wow the jury. They're going to sway them to your side. And when we're talking about both consulting and testifying experts, you can look internal inside a company, like I talked about a minute ago, that maybe you have experts inside the company who are going to be the face for you at trial, and they're going to be the ones explaining, here's what we do every day, here's why we did it right in this instance. Or you may want to go out and hire experts externally. And again, both of those are fine, and both of those are necessary in many cases. So then you have to decide, okay, do I need an expert on every issue or just select issues? And that's difficult. You might have a plaintiff or a defendant expert who throws 20 issues out there and says, I'm an expert on all these issues, and here's all of the things I think you did wrong or I did correct. And you think to yourself, well, shoot, I have 20 issues. Maybe I should hire 20 people. That's usually not the right way to go. You don't want to leave an issue unaddressed, but at the same time, if you hire 20 experts to combat the other side's one expert who put these 20 issues out there, and that really gives credence to all those 20 issues because you thought it was important enough to hire an expert on each point. So you have to balance, okay, how many do I need to make sure that every issue is addressed without overkilling it? Again, you want to counter the other side's issues, but you want to walk the fine line. You don't want to give too much credence to their opinions that really shouldn't hold any water. Another thing to think about when you're considering how many experts you want to use is, in most cases you have liability and then you have causation and damages. So you can split it up that way, and that way you have multiple experts dealing with different issues, and it doesn't feel like too much overlap, and you're able to get multiple all-stars in front of the jury to really support your case. Okay, so we said, all right, when do we need experts? What type do we need, testifying or consulting? How many do we need and on what issues? Now, where do we go to find these experts that we want to use? And I like this case from the 8th Circuit. It says, Rule 702 doesn't rank academic training over demonstrated practical experience. So when you're trying to decide where to go to find experts, you have to really think about, all right, do I need a field expert or do I need an ivory tower professor from a prestigious university? And you think about the fit for your case. What that means is, okay, what venue am I in? What kind of jury pool am I going to draw from? What type of parties do I have involved in this case? Are they sophisticated or unsophisticated or somewhere in between? There are oftentimes when you may want a in the trenches field expert and an ivory tower expert. And so you just have to really think about what's going to really drive home the point for you with the jury, and think about how you're going to connect with the jury on your case, with your facts, with your client. Now, where do you go to get them? There's a lot of places you can look. The most tried and true for me is I use someone I've used before. Of course, you have to balance that with not using them too much. Another good resource for finding experts is talk to your client. Say, hey, have you used an expert before? Or in the industry that you're in, is there someone who you think is particularly good at what they do? Maybe we could reach out to them to help us out. If that doesn't yield any results, I oftentimes go to a trade organization. So let's say if we're talking about engineers or doctors, go to the American Association for Engineers or American Association for Doctors and find out who's on their board of directors or who's their president, because those are the people who are usually at the leading edge of their field, and they're going to be the ones who are invested and they're going to be up to date on things. So that's often a really good resource to go find good experts. And then I'll also look frequently to universities. If I have a particular area that is at issue, I hate to admit it, but I'll use Google. I'll say, all right, Google, what's the best university program in the whole country, and then I'll find the head of that program and reach out to them and see if they might be interested. I typically try to avoid using the experts who advertise a lot or who advertise through an expert agency. Not to say that they aren't good, because I have used them in the past, and most of the time they are good. It just kind of gives off the impression that maybe they're more hired guns, and it's just nice to not have to deal with that and address that when the other side brings up, do you advertise? How much money do you make a year from expert testimony? So that's the way I go about finding good experts. And once I've identified some folks, my method is to just reach out by email or by phone and say, hey, here's kind of what's going on in this case. I see you're a leader in the field, or you've helped us out on another case. Would you be interested in helping us out here? And you want to get comfortable with them. Maybe you talk to multiple people before you make a decision. And then once you, as the lawyer, make that decision, obviously you want to get approval from your client. So those of you who are wondering, make sure you mention that step. I did. And then once the client's on board, you want to get the expert the information that's going to help them help you. So, what that means, that'll be addressed in my next point. So once you're getting them the information, then you have to decide how you're going to use them. For consulting experts, that's easy. They don't have to worry about reports. They don't have to worry about disclosures. But for non-consulting testifying experts, you have to think about, okay, are they going to do a written report? Or are we just going to do a CR-26 disclosure and have them testify to their opinions? So what's the difference between retained and non-retained? So this is more for federal rules. In retained testifying experts, under the federal rules, they're the ones who are recruited to provide expert opinion testimony, and a written report is required from them under the federal rules. But what that means is they have to draft the report, they have to sign the report, they have to list out all their opinions, all the things they considered in forming their opinions. They have to list out their qualifications, other cases they've testified in, and their compensation. So in federal court, if you're a retained expert, you're going to have to draft a report. If you're a non-retained expert, that gets into kind of how we can do it in Kentucky. If you're a non-retained expert, you just have to give that person's opinion. A written report isn't required. And someone who would be a non-retained expert, that might be like an engineer who works for the company or a treating medical professional. You just have to give a summary of facts that they're going to, summary of their facts and opinion without actually drafting a report for them. Now, the Kentucky rules, they aren't as explicit as to what's required of testifying and non-testifying, retained and non-retained experts. So under 2602.4 of the Kentucky Civil Rules, it says written reports aren't required, but they can be used. And all that's required under that rule is the party has to disclose the identity of the expert, subject matter on which they're expected to testify, and the substance of the facts and opinions to which the expert's expected to testify. So if you're in state court in Kentucky, you have to make the decision with your experts. Are you going to have them draft a report, or are you going to just draft a disclosure for them and let the other side depose them if they want to flesh anything out? And that decision can be a difficult one, but typically in cases where I want my experts to prepare a report in state court is if it's real technical issues. But if it's more straightforward, or frankly, if I have a little bit of concern about their ability to draft a really good report, there might be those experts out there who are just spot on and awesome when the lights come on and they're talking and explaining themselves, but they may not do as well through the written word. Those might be the types of experts that I will draft the disclosure for them. I will go over the disclosure with them and make sure they're comfortable with it. And then what you do is you file that with the court, and the other side can depose them if they have any questions. So another important thing to consider when you're using experts is the discoverability of their expert files and their draft reports. And for those experts where you do have them draft reports, we here at the office use WebEx a lot for drafting reports. And that allows us to share the report in real time without creating new drafts, and that way there's never any question down the road about, okay, is this going to be discoverable or not? We also remind our experts that anything they write down may be discovered. So if they take notes, just keep in mind the other side might get to see those. In the federal rules, again, makes clear that you don't get drafts or reports, and you don't get communications between the lawyer and the expert unless those communications relate to compensation or they identify facts and data that the other party can't get in any other fashion. So that's the way it works in federal court and state court. Draft reports or communications between attorney and expert, that's up to the discretion of the judge whether or not the other side gets to discover that. Unfortunately, I don't know why, but Kentucky just won't come up with a standard rule on that, and the Supreme Court hasn't given specific guidance. So what that makes me do is always be careful about what I'm sending my experts. I want to send them objective materials. I want to send them the pleadings. I want to send them the deposition transcripts. I want to send them the interrogatory answers, but I don't want to send them my work product report about my theories of the case and my defenses, because the other side might end up getting that. So you always want to be careful about how you communicate to your experts. Now, one way to potentially avoid that concern and avoid that headache is you, at the front end of the case, you can get with the other side and say, look, we're either going to disclose all our expert file, or we're not going to disclose our expert file, or we're going to disclose these portions of our expert file only. So that's another way you can handle it. All right, just a couple of kind of last points on experts. Besides providing testimony, how else can experts be used? Well, they can assist with drafting written discovery. So at the beginning of the case, when you're sending out written discovery, they might help out on that first draft. If you've already got them on board, they can help you say, all right, here's what I need to really formulate my opinions and solidify them. Or later on down the road, some discoveries already taken place, you might want to have them help you drafting some additional discovery requests. Experts can also assist in developing case theories and strategy, obviously. They can assist with reviewing the opposing party's written discovery. So once the other side sends you some discovery interrogatories, requests for production, you can ask your expert to help you formulate some answers to those. They can assist with developing deposition questions for opposing parties' technical and expert witnesses. I've even had experts sit in with me during the deposition for the other expert. That can be very valuable. Of course, it costs money, but usually money well spent. So that's really it for the experts. I mean, you all know and appreciate experts are critical components of litigation, and frankly, they can often be a large part of your litigation budget. So it's really important to think through what kind do you need, what issues do you need them to address, how many do you need, where do you go to get them, and how are you going to use them. With that, I'll turn it back over to Craig.
All right, let's. So we've got about 5 minutes or so, and I think we can talk about aging infrastructure in that time period. A lot of these are I guess, areas that I would suggest are good things to think about in terms of how litigation may impact your maintenance and your replacement of aging infrastructure. And so these are just things to think about in the event that litigation was to come. The critical part, I think, if you're looking at potential for litigation, or you're just thinking about aging infrastructure and replacement of that, is the inspection procedure protocols. And so what do we mean by that? Well, in a lot of industries, certainly in a lot of utilities and in some other manufacturing and on-site management type of industries, there are standards set by regulation or by statute. And to the extent that those exist, you want your inspection protocols and procedures to follow those, and frankly, to be a little more rigid than whatever is in the statute or the regulation. More rigid is always better in litigation. Just meeting the standard is typically not something a jury wants to hear about. So just as an FYI, again, in the cases I've tried over the years, when you're talking about just meeting the standard, you're losing the jury. And so a little more rigid than within the standard is important. I think, not only do you need the inspection protocol and the procedure, but you need to document those inspections. Again, these are somewhat obvious in some of our more regulated industries, the utilities, the coal industry, those areas, somewhat in the medical areas. There are fairly strict standards about aging infrastructure and record keeping and protocols for inspections, but these are good rules to think about regardless of the industry that we're talking about, or frankly with universities and academia. It's also important to think about the buildings and the stairs and the elevators and all of that sort of thing. So a couple quick rules there. The inspection procedures need to be written down. The inspections need to be documented, and those documents need to be kept. And more rigid than whatever their statutory or regulatory standard is critical. Next for us are creating a set of acceptable standards in writing. And you might say, well, what does that mean exactly? Well, at its simplest form, something that deals with what is required to maintain the equipment, the facilities, whatever it is that's used by the employees or the public on a regular basis. Having a set of standards that guide everyone in the company's work or efforts in that regard is critical. And so creating those standards and vetting those, and then having those in enough detail that you can say to a judge or a jury, we have standards and we followed those standards, and those standards are consistent with industry practice. And in fact, they're more rigid than industry practice. And so, obviously, when you're creating those, you want to incorporate all the relevant codes and statutes and standards and all that sort of thing. When should aging infrastructure be replaced or repaired? Well, obviously, that is more often than not a business decision. In most industries, the question is, does it still work? And does it still function efficiently? And if yes, then we're going to keep it. There are a few areas where you've really got to think ahead about legal issues, legal requirements. OSHA has become so much more rigid in recent years in terms of workplace safety that almost every industry, including those that are labor intensive as opposed to manufacturing intensive, I'm talking about hospitals and law firms and areas like that. You've still got to comply with those OSHA standards. And when things are old and need to be replaced because they may break or likely to break, then replacing those will prevent a lawsuit down the road. That's just the bottom line. The preservation of evidence and the impact on potential tort litigation. Frankly, what is critical, and maybe we'll wrap up with this because I think this is a good place to end the infrastructure discussion. What's critical is that you have standards in place, the standards are followed, and that you document that following the standards, and then either repairing, maintaining, or replacing whatever the infrastructure is. And that can be anything from steps to the floor to huge pieces of equipment, to a manufacturing facility and safety exits and that sort of thing, all the way down to some of our clients. We represent a number of arenas and stadiums, companies that own arenas and stadiums, and that can be maintenance of the exit signs and the accessibility to an exit. It's not blocked. There's not some structural problem with it. So all of those things are infrastructure, and all of those are important in terms of tort litigation and the defensibility of the same, whether you're at a university, an industry, a stadium, an arena, a theater, whatever it is. If you follow those guides, I think you'll be able to deal with aging infrastructure in an efficient and business-friendly way. I think that's it for us.
Yeah, thanks everybody. So Craig and I will send out a follow-up email with the activity number for getting CLE credit. But we appreciate you being here today in the lunch hour. It'd be nice to see everybody in person, but it is what it is. The next presentation in our CLE series is going to be January 27th, and that'll be an ethics credit. AJ Singleton will be presented, so be on the lookout for that. And along with the email with the activity number, there's going to be a very short survey, so we'd really appreciate it if you take the minute to complete that as well. And hopefully you got something out of today. And thanks for spending time at your lunch, and stay safe.
Thanks, everybody. Hope to see you soon.